repealing and reforming those laws in order to secure the rights of LGBT plus people. And legislative reform can be a lengthy and complicated process, as I know many people will know, and that requires the attention and dedication of a range of actors to be successful. So I'm thrilled that we're joined today by speakers who have worked on successful legislative reform around the world, and we pay tribute to the work that they are doing. And now, forgive me if I pronounce anybody's names wrong. I will do my very best to get them spot on. But Tia Braun is the director of the Human Dignity Trust, where she's worked on both strategic litigation and legislative reform in multiple countries over the past 8 years, successfully leading the strategies that have led to decriminalisation and other human rights court victories for the LGBT plus people, and the development of several draft bills to reform outdated and discriminatory laws. Next, we have Kim Simplis Barrow, and she is Belize's Special Envoy for Women and Children and is the wife of the Prime Minister. Kim, you're very welcome as well. She has a long list of accolades to her name, including chair of Spouses of CARICOM Leaders Action Network. She's a global ambassador for the Special Olympics, and she is the founder and director of the Lifeline Foundation. And as Special Envoy, Mrs. Barrow successfully advocated for the passage of legislation on the commercial sexual exploitation of children and human trafficking, as well as the passage of amendments to the criminal code for stiffer penalties for all perpetrators of sexual violence against children. She's currently working on the introduction of equal opportunities and hate crimes legislation in Belize with HDT's support. Next, we have Bernard George. And he is a member of the National Assembly of Seychelles, who was deeply supportive of and involved in the repeal of that country's law criminalising LGBT plus people. Bernard, you're also very welcome. Lovely to see you. He is a lawyer and a broadcaster and was first elected to the Assembly in 2002, representing the Seychelles National Party. He's currently the senior partner of Georges & Co. attorneys and regularly advises NGOs in the Seychelles on both political and legal issues. In 2015, he was appointed as a judge for the Court of Justice for the Common Market for Eastern and Southern Africa. I'm Hannah Bardell. I'm the Member of Parliament. I should have introduced myself properly at the beginning, but I'm the Member of Parliament for the Livingston constituency in Scotland, which is just between Edinburgh and Glasgow. I have been an MP in the House of Commons since 2015, and I came out the same year that I got elected, and I'm one of, I think, a record number of LGBT members in the UK House of Commons, and a very proud one at that. So without further ado, I'll come on to a couple of terms of housekeeping. We are recording today's session. We're also going to be using the Q&A function. So for those watching, if you have any questions, please feel free to add them to the Q&A box during the session, and we will endeavour to answer all of those questions either during the session or in the Q&A section at the end. And firstly, I'd like to invite Tia to make some remarks.
Lovely, thanks very much, Hannah, and thanks to you and the entire APPG for co-hosting this webinar with us, and to everybody, a great turnout of participants for joining us. I think a lot of the people who had signed up are probably already familiar with the work of the Human Dignity Trust, but just briefly, we are international human rights lawyers working globally to support the eradication of laws criminalizing LGBT people. So laws variously termed as unnatural offenses, buggery, gross indecency, those types of laws, which still exist in 72 countries today, half of which are Commonwealth countries, and most of which still have colonial era penal codes. 60% of those criminalizing countries criminalize both men who have sex with men and women who have sex with women, both of which capture trans people. These are issues that affect the entire LGBT community, both directly and indirectly. We also help challenge related repressive actions that are justified by the criminal law. So for instance, restrictions on freedom of association for LGBT people, forced medical examinations, asylum issues, and that type of thing. We have historically focused exclusively on strategic litigation, so using the courts as a mechanism to affect change and asking courts to strike these laws out as a violation of human rights principles. But it was apparent to us very early on that there were links between these laws and other colonial era sexual offenses laws. For instance, when we and our partners are asking a court to strike out a buggery law, we had to ask them to do a limited strikeout. So the buggery law had to remain on the books to protect against anal rape, because the rape provisions in these colonial era codes only captured female victims of rape. So you had this disconnect between the protection against rape varying, including the maximum sentences, the evidential rules based on the gender of the victim, which obviously was an unsatisfactory result. So the rape laws themselves also needed to be reformed. And then if you look at more widely at the entire sexual offenses codes in many countries, there are a whole raft of other issues that are out of date and discriminatory. So the very definition of rape being too narrow, marital rape still being lawful in half of the Commonwealth, ages of consent being different for males and females, people with disability being referred to as idiots and imbeciles, and this type of thing. So the need for reform includes, but certainly isn't limited to, the criminalization of LGBT people. And we know that a number of countries that have decriminalized LGBT people in recent years have done so through legislative reform, and often wholesale legislative reform inclusive of, but not limited to, decriminalization. So we wanted to look into that in a little bit more detail. In terms of legislative reform, if we look at just the past 10 years, 13 countries have decriminalized consensual same-sex intimacy, including Gabon, just in the last couple of weeks, 9 of which included at least some element of legislative reform, as laid out in the slide that you should see there now. So we've been working over the past few years to understand the processes and the patterns of those successful reform initiatives, particularly in the Commonwealth, given the shared history, from which we could then leverage opportunities to achieve similar reforms elsewhere. And so commencing in January of 2018, as part of this work, we commissioned a series of country case studies, which are the subject of our discussion today. And that work was funded by Global Affairs Canada with extensive research and drafting assistance from one of our legal panel firms, Descartes. And it has richly complemented our 2-year FCO-funded work supporting legislative reform in the Commonwealth, actual technical assistance to advance some legislative reform. So thank you to everybody who has contributed and supported this work. So the case studies, they look at 6 of the jurisdictions that had decriminalized through legislative reform when the research was commissioned in 2018. And those 6 countries were selected to ensure a spread of geographic representation, a mix of different models of legislative reform, and of course, places where we could access key stakeholders involved in the reform. And there's an in-depth report on each of the countries in the case study on our website. So for anybody who's interested in the real detail of how these countries achieved from A to Z the legislative reform, they're very detailed reports that look at the process that was involved, who the champions and drivers of reform were, what obstacles were seen and how those obstacles were overcome, what the timeline was, and the process step by step. It's all laid out in a lot of detail in these case studies. The research to come up with those case studies involved a mix of country visits, desk research, and stakeholder interviews with civil society leaders, political leaders, policymakers, and journalists. And the specific countries that we looked at, all of which previously had colonial era penal codes in place, were Palau in the Pacific, which in 2012 modernized its sexual offenses laws, and a couple of years later updated its entire penal code. Belize, which in 2014 modernized its sexual offenses laws, and in 2016 achieved decriminalization of same-sex conduct through the courts. Northern Cyprus in 2012, we had filed a case challenging criminalization at the European Court of Human Rights, and that prompted the repeal of the criminal law in 2014. Mozambique, which in 2015 did a wholesale updating of its penal code, including decriminalization. Seychelles, which in 2016 affected the repeal of the law that criminalized same-sex conduct just on a standalone basis, just that one provision. And in 2016, Nauru, which did a wholesale updating of its criminal code. So those are the case study countries. And just in terms of a snapshot summary, we pulled together a few of the learnings from those country case studies. Firstly, in terms of the models of change. So we identified 3 broad models of reform, each with different benefits and drawbacks dependent on a range of factors. So one of the models of reform is wholesale reform of criminal codes. And this was the preferred route for Mozambique, Nauru, and Palau. In some cases, those penal codes had been modified on a piecemeal basis or an ad hoc basis, but generally they remained largely untouched from colonial times. So they did an entire rewrite of the penal code. The second main model of reform is broad sexual offenses reform. So where a country is tackling just the sexual offenses chapter of its penal code. And that was the model of reform in Belize, Northern Cyprus, and Palau. Palau did a bit of both. As you saw, there were 2 different stages that they followed. And happily, Kim Simplis Barrow is here with us today, and she'll speak more on the experience of Belize. So just of those 2 of the 3 models, we found that those broad approaches had certain strategic advantages. Firstly, presenting the amendments as a package and through certain prisms, such as child protection or non-discrimination, not only provided the opportunity to address a variety of shortcomings in the criminal law, but it also afforded some cover for more controversial issues, such as decriminalisation. And importantly, the reform efforts were made more credible and probable as part of a suite of reforms that the legislatures could and did coalesce behind. The third model of change is targeted reform of a specific sexual offense provision. So it's not the entire penal code, it's not even the entire sexual offenses chapter of the penal code, it's one or 2 provisions within that chapter. And Seychelles is an example of a recent targeted reform, making it one of a handful of African countries to have recently taken positive steps to repeal their laws criminalizing same-sex conduct. And again, we're very honored to have Bernard with us speaking more on the experience of Seychelles. A targeted approach coupled with clear political leadership enabled a swift process of reform, and the expeditious nature of the process avoided entangling the issue of decriminalization in lengthy deliberation, which it could have led to the reform being indefinitely delayed. So it worked really well in Seychelles. There are potential risks with that model, though it could be in other places, particularly if there are multiple discriminatory provisions in the sexual offenses chapter, as a piecemeal approach is both lengthier. If there are actually a number of provisions that need reform, doing it on a piecemeal basis is both lengthier and obviously related to that more costly in the end. And it can result in certain segments of society having their lives left hanging in the balance. But so those are the 3 broad models of reform that the case studies revealed. Then in terms of the drivers of reform, so this is, the case studies look in detail at what factors prompted, caused, accelerated, or enabled the legislative reform. And we identified 6 main drivers that were present in various combinations across the case study countries. The first is political will, and that was present in all of the jurisdictions we studied, and it clearly is important. Civil society advocacy and action, present virtually everywhere. International and regional support was also present in all examples. Engagement of state or national agencies in certain of the countries. Related litigation on some more of the issues that in need of reform. And finally, a lack of significant opposition from faith groups. So that table that you see now sets out the extent to which those were present in the case study countries. So I'm going to focus just on 3 of the most prevalent drivers that are most relevant to our discussion today and just touch on them briefly. So firstly, in terms of political will, clearly that's a vital factor in achieving any sort of legal or policy outcome. And as one would expect, it was therefore visible in all 6 case studies, albeit to different degrees. So for instance, in Belize, broad cross-party consensus and support for the Criminal Code Amendment Bill that reformed Belize's sexual offenses chapter was especially pronounced, which enabled the reforms to pass pretty swiftly through the legislature. In contrast, in jurisdictions such as Nauru and Mozambique, whilst there was a common understanding and agreement that the criminal law needed to be modernized, the political will to reform was less explicit and more tacit. Another way that we saw political will manifest itself was through the prominence of specific individual decision makers or political champions who were prepared and able to lead the charge with their influence, and that can obviously be crucial and transformative. Political champions were especially crucial to the reform efforts in Belize, Palau, Northern Cyprus, and Seychelles amongst our case studies. The second category of driver I'll touch on is civil society. In almost all of the country case studies, civil society was either at the forefront of the campaign for legislative reform, instigating and initiating the process, or heavily involved in the legislative process once reforms were underway, in some cases pushing the boundaries of what was possible. In Northern Cyprus, Mozambique, Palau, and Seychelles in particular, a relentless campaign forged by many domestic civil society groups, in some cases with support from international organizations, placed reform firmly on the legislative agenda. Working intersectionally, particularly the collaboration between LGBT groups and women's organizations was an important element which broadened civil society groups' campaigns, their appeal and their reach, and it strengthened the advocacy efforts. And that was most apparent in Northern Cyprus and Mozambique. Equally, the development of a multi-pronged strategy, so involving a mix of advocacy and lobbying, litigation, international and regional collaboration, and awareness raising was very effective in Northern Cyprus, Belize, Mozambique, and Seychelles. And these actions combined to apply and maintain the necessary political pressure for the reform efforts to succeed. And the third category I'll touch on in terms of drivers is international or regional support. The international and regional communities and mechanisms supported reforms in all of the case study countries and did so in a number of ways. So this really highlights their importance. Firstly, there was a clear role for UN treaty bodies and agencies and other regional organizations to highlight, for instance, the prevalence and abuse of violence towards women and children, sexual violence, as well as various gaps in existing legal frameworks. And that primarily occurs through state reviews, periodic reviews, or thematic studies. Secondly, and crucially, the changes made to sexual offenses frameworks in these countries were often prompted by a desire to fulfill human rights obligations and to conform to international human rights standards. So there was that drive and motivation coming from international obligations. Thirdly, in a number of case study countries, governments drew on the resources and expertise of international and regional organizations to help develop the reforms. This can be key as law reform, as Hannah touched on, it's a complex and a technical process, making this kind of cooperation particularly beneficial for smaller countries that may not have sufficient domestic expertise or capacity, including critically sufficient legislative drafting capacity. We found that was a particularly acute issue in Palau, Nauru, Mozambique, Northern Cyprus, and Belize. So virtually all of the studies and the ones in which multiple reforms were being undertaken. And clearly engaging with international, regional, bilateral assistance allowed those seeking reform to leverage the experience of those who had already implemented similar changes. So there was no reinventing of wheels. And fourthly, multilateral engagement, such as through the UN's Universal Periodic Review process, or with the EU or Pacific Islands Forum, as the case may be, and other sort of bilateral or diplomatic engagement were also influential in the reform processes in a number of countries. The next sort of topic I'll touch briefly on in summary is the legislative process. And that clearly the legislative process in each of the jurisdictions of the case study series were unique, and therefore the reform processes differed, and they're all laid out in great detail in the case studies themselves. But some comparisons can be drawn from the different experiences. So just three quick topics before I wrap up. One is the duration of the process of reform. It can be an extensive and protracted process, and it's obviously susceptible to political instability or volatility and things of that nature. But the case studies also demonstrate that a genuine determination for reform can weather those temporary delays or obstacles, and that persistence will ultimately prevail, and did in these countries. And while the process can be lengthy and discontinuous, there can be stops and starts along the way, the actual passage through the legislature can also be achieved expeditiously, as was the case in Belize, Northern Cyprus, Seychelles, and Nauru. Another process issue is drafting. So of the 6 jurisdictions explored, 5 either explicitly made use of model laws, one country in particular, Palau, or drew inspiration from existing precedents and frameworks from other countries. Most of the other countries had that resource. And obviously it's paramount that such precedents are carefully adapted to fit the legislative regime of the country undergoing the reform. So local legal experts have to be involved early in the process and throughout the process. And finally, public engagement. So public awareness and support, we found in the case studies, is vital to achieving, it's often vital to achieving the legal reform, but also to changing the social norms, the underlying social norms, and timely consultation, both public consultations and private stakeholder engagements prior to introducing any bill to Parliament will typically facilitate a smoother legislative process, and importantly will enhance the implementation programs that have to follow any law reform. And conversely, in the case study countries where there was more limited consultation and public engagement, such as in Palau and Nauru, there was a resulting lack of clarity and understanding regarding the sexual offences reforms that were made. And that can impact the effective implementation of those changes going forward. So, obviously we want the law reform, but we want it to actually have an impact in people's daily lives. So implementation is a really key part of it that has to be factored in from the outset. And lastly, all of the case studies illustrate that there will always be some degree of opposition from certain segments of society to some or all of the reforms, but that opposition need not paralyze progress. All of the countries that we studied have deeply religious societies, diverse cultural backgrounds, and all of the governments in question understood and accepted that while there may never be complete consensus, there probably never will be complete consensus, reform is possible. So these case studies really are encouraging for any other countries that might be considering reform. So I'll leave it there, Hannah. Thank you very much.
Thank you so much. Yeah, that was just a real tour de force of the incredible work that you and the Human Dignity Trust have been doing, and the work of all of those nations. And hopefully some comfort, I think, to anybody who is coming to us or watching from countries where being simply loving who you love or being who you are is a criminal act, which still for me seems unthinkable. Mrs. Barrow, Kim, we'd love to come to you next, if that's okay. Thank you for joining us. It's a huge pleasure to have you.
Thank you. Thank you so much for having me. First of all, greetings from Belize. I am delighted to join you today to share the Belizean experience of law reform. For more than a decade, we have been reviewing our discriminatory colonial era laws. We have been on a long journey, and today I'll be speaking about some of the lessons we have learned. From reforming our sexual offences legislation over a decade ago to our current work to enact the Equal Opportunities and Hate Crimes legislation. We began the reform of our sexual offences legislation in 2008, sorry. As in many countries, our criminal code, which was imported by the British, reflected the values and practices of Victorian times, which were, of course, incongruent with modern-day Belizean society. The language featured in our legislation was outdated and deeply offensive, such as referring to people with learning disabilities as idiots. But the further worry was the content. Married women had no protection from being raped by their husbands, for example. Meanwhile, boys and men were not even recognized as potential victims of sexual assault. In other words, nothing in the old legislation valued or respected the rights of all our citizens, male and female, young and old, able-bodied and disabled. As a special envoy for women and children, I have always been heavily invested in the prevention of sexual assault, the victims of which tended to be young girls and boys. However, even when sexual offenses were being reported and investigated, crimes were often not properly recognized, nor were perpetrators given adequate penalties. I knew that what we needed was a new rule book. As such, in 2013, 5 years since Judith Alpuche, the CEO of the Ministry of Human Development, and I first met to set in motion this plan to reform the criminal code, this legislation passed through Parliament. These were 5 very long years. And so in the time we have today, I'd like to share with you the 3 points I believe were key in this process. For one, we made strategic alliances with civil society, faith groups, political parties, thought leaders, and also with people from across the political aisle. We needed influential individuals to get behind this initiative if it were to ever stand a chance. Secondly, we kept our message strong and clear. The focus was always on positive messaging and practical examples. And last but not least, we tried to engage everyone rather than dismiss those opposing our initiative. And I believe that this approach did change many hearts and minds along the way. On this note, I also think it's important to share with you some of the challenges we faced during this time, such as our lack of capacity or the nature of government bureaucracy. Due to the backlog of cases on the Attorney General's desk, we had to patiently wait our turn for a senior lawyer to draft the revised criminal code. A lack of resources prolonged the reform process. The other main challenge was the opposition received from the more vocal sections of the evangelical church. Who took issue with the proposed gender-neutral legal language and deemed this bill as a part of the so-called gay agenda. In parallel to the legislative reform process, Caleb Orozco, a prominent LGBT Belizean activist, was challenging the provision in the criminal code that criminalized LGBT people, supported by HDT and others. As I'm sure many of you know, he was successful in this endeavor when in 2016, the Supreme Court found in his favor, and that was upheld by our Court of Appeal in December 2019. Taken together, Caleb's work and our reform for sexual offenses legislation has left Belize with a far stronger criminal code, one that better reflects the values of Belize and international human rights standards. Personally, the reform of sexual offenses legislation was a rewarding journey, which will be a proud part of my legacy. However, this was only the beginning of a bigger journey towards achieving a fair and just society. As you may know, we have now decided to go the extra mile and are in the process of introducing the Equal Opportunities and Hate Crimes legislation to protect all Belizeans from discrimination, violence, and stigma. The lessons from our reform of sexual offenses and the success of the Orozco case set the stage for us to be really ambitious in our aim to create a Belize where all people are protected by the law, regardless of their sex, race, ethnicity, ability, sexual orientation, or gender identity. Over the past 2 years, with the assistance of the Human Dignity Trust, we have been working to develop
We maybe just lost, we might have just lost Kim there. Oh, we got everybody else. Yeah, okay. We'll hope that Kim comes back on, and in the meantime, Bernard, and we will thank Kim now and hopefully when she comes back for that incredible contribution about Belize's journey. But in the meantime, Bernard, if we could come to you, and if we get Kim back, if we can pop back to her, is that acceptable for you?
Absolutely it is. Pull the rug whenever you want.
That's incredibly kind. Thank you so much.
Good evening, everyone. And may I say how thrilled and honored I am to have been asked to share the Seychelles experience with this incredibly august bunch of hardworking people. I must say that I feel a bit of a cheat because in Seychelles we did the bare minimum. As Thea said, we only changed one provision in the penal code, and I wasn't even involved. So joining people who have dedicated their lives in a large number of years to the cause makes me feel a little inadequate. So please bear with me. It's evening here in the Seychelles, and night is drawing in. There's a film of rain sweeping across the mountains over there to my right. Just so you know where I'm coming from. We are a very tolerant society, and I am a dyed-in-the-wool liberal. So with those parameters, you'll understand why I'm involved, despite the fact that I did very little. We tried in this country to change attitudes not through legislation, but through court process. And I've been involved in a number of attempts over the years. I defended the last gay person to be charged under Section 151, which is our Victorian era penal code provision, which we were able to get rid of in 2016. And I took rather an interesting case. It was a trans person who had been recognized as having changed her gender in every country in the world, except the country of her birth. She went to the civil status office and said, well, I would like the gender on my birth certificate to be changed. Will you please do it? And they showed her the door. Kim is back. Would you like me to stop now and continue later?
If that's okay, Bernard.
That's absolutely fine. That's absolutely fine.
Incredibly kind. Kim, we lost you there for a second. These things happen. We're living in a very different world. So we agreed Bernard has kicked off very briefly, but was happy to come back to you so you can finish. So.
Yes, thank you so much. Thank you. Over the past 2 years, with the assistance of the Human Dignity Trust, we have been working to develop and draft the Equal Opportunities and Hate Crime legislation, accessing regional and international expertise has been vital to building this new legislative framework. The model of work employed by HDT in this work, which promotes the cross-fertilization of local and regional knowledge with international expertise, has had, in our experience, a wide range of positive effects. This approach has ensured that any work carried out is tailored to our local context.
I think we might have lost Kim again. If we go with a standing arrangement, George, that we pop back to you when Kim drops out, is that okay? Bernard, sorry.
Yes.
If we do that, and hopefully we'll get through both of your contributions, that's very kind of you. If we could come back.
Thank you very much.
Thanks, Bernard.
I'm so sorry to have to bore you, because Kim really was doing a great job, and I was absolutely thrilled to hear of the Belize experience. As I was saying, we did very little, and but I think we need to consider that the little that was achieved went a long way for our country. We're an extremely tolerant society, despite the fact that somebody was charged and brought to court under our Section 151 buggery law. That only occurred because the offense had been committed in public. Nobody had been charged or brought to court for decades for private actions. So had this person not been caught in public, the thing would never have got to court. But I was speaking earlier of the court case that I was doing for the transgender individual. She was shown the door by the Civil Status Office. She came to me and I said, well, hang on a minute, we've got a fantastic constitution. We have an equality provision which is second to none in the world, and which says that there will be no discrimination on any ground. So I'm going to take this matter to court and I'm going to win it for you. I lost. I said, well, never mind, we'll take it on appeal and we'll win it on appeal. I lost. So although we have the statutory enactments, although we have the roadmap, success is not always evident. And I think this is something, an experience that has been shared by more than one country over the years. It is a long and it is a complicated and it is a difficult fight. And I think we did it here and we succeeded in repealing Section 151 simply because we had a perfect storm of events. We had an engaged LGBT community. We had a willing government, as Thea explained earlier. We had a president who was committed to doing it at the time. We had an attuned parliament. The parliament was entirely in favor of it. And we had a handful of bold people supported by the Human Dignity Trust and various other international and regional organizations. So there was a perfect storm. It couldn't have been done without it. The fact that the National Assembly at the time that the law was repealed, or the section was repealed, had no opposition, of course, was a contributing factor. But I think it would have happened anyway. What you need, and again, Thea, if you forgive me for taking your idea, what we need is a person driving the agenda. And I think that is extremely important, which is why I was enjoying Kim's presentation so much. If you have somebody driving the agenda, they will make it happen. And we will eventually here get this trans person what she's looking for. We will do it through court action, because we've been told if we go to the Constitutional Court, and I won't go into the reasons why we didn't do it the first time around, if we go to the Constitutional Court, we can expect that we will obtain satisfaction. So the elements are there. All we need is one person to drive it. And despite despite opposition, and I've heard this many a time, the opposition comes generally from, or principally from evangelical groups, but despite the opposition, and there was opposition here from them, a strong driver, and we had a number of them. We had not only the president, but also the Chief Justice, who engineered, if I may say so, the whole process. If you have some bold people, and if you have a good LGBT caucus, which we had, and a parliament that is focused on doing what is right, despite the fact that there is opposition, you will get it done. So what have we done apart from that? Nothing until last week, and this is the problem with this ebbing and flowing of the legislative and the judicial tide. You cannot get in societies such as ours everything in one go. You have to nibble away at it until you get to the bogey at the center, and then you confront it. And what has happened last week is out of the blue, because frankly, Section 151 repeal was something that hadn't been thought of for very long. It happened quickly. Out of the blue, the Attorney General goes on television and informs us that he is preparing a series of laws against hate crimes. So one little egg that was laid in terms of LGBTQ people is now going to deliver a whole range of laws against hate crimes. So one message that I can draw from this is perseverance helps. If you knock away at it, eventually you will get to the bogey in the center and you'll be able to stare it down. Thanks, Hannah.
Thank you so much. Well, that's an incredibly powerful message to finish on, and hopefully we will get Kim back, hopefully, and she will be able to, I don't know if she's managed to get back in. Not at the moment, but we actually have I think if it's okay, we'll jump straight to a question, because we've got a question in from someone that relates, I think particularly to the tactics and strategies that can be used. And this question comes from Murilo Cambruzzi. Thank you very much, Murilo. And they ask, most of the case studies presented and the countries that have recently decriminalised same-sex relationships have small or mid-sized populations. Is it easier to implement these reforms in such countries, or is it only a coincidence? What are some of the challenges on decriminalisation in countries with big populations such as Kenya, Nigeria, Ethiopia and Pakistan? Who would like to go first? Tia, do you want to, can we come to you first?
Yes, sure. Yeah, I can touch on that. I mean, I don't think it's entirely coincidence. And Kim and Bernard can speak to their experience, but I think in many ways it is easier in a smaller jurisdiction. On the one hand, I think it's probably a bit of both. It's harder and easier, but they'll be able to speak to it. On the one hand, in a small jurisdiction, everybody knows everybody. There are certain pressures because of that, and difficulties because of that, and people putting their head above the parapet, and these sorts of issues. But on the other hand, the infrastructure and the processes, the legislative processes, involve smaller numbers of people. And if you have those political champions and you have, at least a broad political will, even in the face of certain opposition, it's perhaps easier to affect change. I know as well that, within the Commonwealth in particular, a lot of small jurisdictions do really take advantage of learning from and sharing experiences with other small Commonwealth jurisdictions. And within the Commonwealth infrastructure itself, there's, there are these mechanisms for small states. So even that sort of information sharing, willingness and need for information sharing is more systematic. That said, obviously, there have been reforms of these kinds in major jurisdictions. I mean, the case studies that we did were just a handful of the recent countries. Added to that, a number of the countries that criminalize are small jurisdictions. Many of the small islands in the Caribbean, many of the small islands in the Pacific, for instance. So our case studies aren't indicative of the whole process of legislative reform. And there are, if you look broader than the case studies, if you look at the history of decriminalization, the number of countries overall that have decriminalized through legislative reform is much longer than the number that have decriminalized through the courts. But there have been a number of reasons for that, whether it's small countries or large countries. So in Europe, for instance, in order to join the Council of Europe, countries had to get their laws in order and be human rights compliant. And so there was a big raft of reforms that happened in small and large jurisdictions around Europe. So that was a huge part of the list of legislative reform. So I think, it's a complex question, but I'd be interested in Bernard and Kim's thoughts on that, coming in particular from the small jurisdictions. Do you think that made it easier?
Bernard, can we come to you and then we'll come back to Kim? Is that okay?
Yes, I don't think size matters, to be very frank, although, because there are challenges. I mean, the fact that it's a small country and everybody knows everybody else helps, but it also hinders. And it, I think, especially hinders because everybody knows everybody else and everybody knows exactly who's who and who does what. In this country, I can be absolutely clear that if there wasn't the presidential will, I'm not even going to talk about the political will, if the president hadn't put his weight behind it, it wouldn't have happened. It's as simple as that. You see, the issue that we're talking about is not a vote puller in elections. And that's the problem. Nobody wants to confront it at any time, because if anything, the perception is that it's a vote loser. So most people put it on the back burner and there it remains. So you do need massive political will and a strong driver, irrespective of the size of the population.
Sure. Thank you so much, Bernard. Kim, I don't know if you were able to hear the question.
Yes, I did.
Fantastic.
Would you? I have to agree that there has to be political will. I think whether you're a small country or a big country, if there's political will, and when you have strong champions for these pieces of legislations that are not always popular with certain sectors of society, you can achieve the success that we've been able to achieve. So to me, it really doesn't matter if you're small or if you're big. We have the same challenges. It is that push to move forward and to really fight for equality and human rights for all. So yeah, I think the main ingredient in all of this is that political will.
Fantastic. We've got, I don't know if you had anything further you wanted to say. I know you got cut off in the middle of your comments, Kim. Was there anything further you wanted to talk about in terms of Belize and the work that you've been doing there before we've got a couple more questions?
Yes, let's hope I don't get cut off again, because the third time would... Yeah.
It's modern technology. Was there anything else you wanted to add, or are you happy for us to go on to questions?
Yes, let me just finish up my presentation. Over the past 2 years, with the assistance of the Human Dignity Trust, we have been working to develop and draft equal opportunities and hate crimes legislation. Accessing regional and international expertise has been vital to building this new legislative framework. The model of work employed by HDT in this work, which promotes the cross-fertilization of local and regional knowledge with international expertise, has had in our experience a wide range of positive effects. This approach has ensured that any work carried out is tailored to our local context, led and guided by Belizeans, while also benefiting from the input of experts from all around the world, whether they be academics, civil society experts, or lawyers. To give you an idea of the extent of this cross-fertilization in our case, the team put together by Human Dignity Trust, who worked on drafting our equal opportunities and hate crimes legislation, has members from Australia, Barbados, Belize, the Cayman Islands, and the UK. Using the CARICOM model anti-discrimination legislation as a starting point, they have studied similar models of legislations from across the world, consulted with relevant stakeholders in Belize, finalizing a bill that I believe will best serve the Belizean people. The international knowledge exchanges facilitated by this program, much like this one, are, in my opinion, invaluable, as they have allowed us to build on all the work that's already been done across the world, and to be able to better anticipate and address the inevitable challenges arising along the way. The final Equal Opportunities Bill provides comprehensive anti-discrimination protections on 19 protected characteristics, including sexual orientation and gender identity. When it passes, it will make Belize a regional leader in protecting minorities from discrimination and will be a powerful example of what small states can do to uphold the rights of their citizens. We are looking forward to introducing it to Parliament in the coming weeks. The Hate Crimes Bill will recognize and protect against hate-motivated crimes, including those that are targeted at LGBT people, and will provide for stiffer sentences. If passed, it will be the first of its kind in our region, and I'm incredibly proud of that. And so, to lessons learned. Firstly, when faced with strong opposition and backlash, we learn to pick our battles carefully. Or, as we like to say in Belize, don't throw stones at every dog that barks. Secondly, in the face of limited resources, international assistance is a vital tool to speed things up. This is particularly true in the context of the Commonwealth, where there are so many commonalities between nations when it comes to legal frameworks. Thirdly, building a strong coalition of diverse stakeholders, from civil society, faith groups, political parties, and from the community at large, is key to ensuring that reforms reflect our diversity as a nation. I am immensely proud of how Belize has worked to improve the lives of all our citizens, gay or straight, male or female, Black or white, disabled or able-bodied. Beyond just making a lasting impact on the lives of Belizeans, I'm also incredibly proud that our experience, that lessons we have learned throughout these reforms can be shared with others who are looking to undertake similar reforms. Our experience over the last decade of reform in Belize is that progressive change can be achieved, even if the journey has been arduous and prolonged. The rewards of our small Caribbean nation have been worth every effort. Thank you.
Thank you so much, Kim. It's so uplifting, and I hope and I imagine that Belize will go on to be a leading light in your region, and hopefully lift other countries up and inspire them to bring their legislation up to scratch. We've got a few questions that have come in, so I'm going to take them in twos, if that's okay. First of all, from Matt Salek, he says, thank you all for great presentations what role can the media play in the reform process? And then a really excellent question from Susie O'Connor, this was something that was on my mind as well. She's saying the focus is on this webinar has been on the decriminalisation of homophobic or transphobic laws, often colonial era legislation. What do the panellists think about the problem of recriminalisation, i.e. countries reversing legislation guaranteeing LGBT plus equality? I think that's particularly pertinent given what we've seen in Russia and America. You know, progress is precious, but it's not guaranteed. And once we've made progress, we can't stand still. Tia, will we come to you first?
Sure. Yes. Well, so taking those in order, I think the role of the media is immense, as always, and multiple layers of that. Obviously, the first layer in many countries is building alliances with the media, educating the media so that you eventually have, you know, favorable hearts and minds reporting in the media, which, as several people have mentioned, is key along the way. So depending on the country context, you know, there's always a role for the media to just engage on the issue or understand it if they don't already, and for whether it's civil society, human rights defenders, or others like Kim and everybody that she mentioned that we're building allies along the way, right from the outset. The media has to be central to that as well. And then, you know, clearly the media covering these issues, reporting them at least in a balanced way. Well, it should obviously be in a balanced way, but in an informed way. And that's proved crucial, whether it's strategic litigation on this issue and these issues in particular, whether it's strategic litigation or whether it's legislative reform. You know, we as HDT, we always have a media and communication strategy around everything that we do in collaboration with our local partners. But it's key. It's absolutely key, not only to the effectiveness of the change, but also to the hearts and minds that have to accompany the change. So I think the role of the media couldn't be higher. On the second point, yeah, I mean, this relates, I think, to another question that somebody put, but the way I see it in terms of this work, there are, well, I was going to put it into 3 categories. Maybe there are 4 categories. So looking globally, there are the hostile countries, if I can put it that way in a nutshell, the hostile countries, and some of them are, you know, not only criminalizing already, but seeking to make their criminal laws even worse. Uganda, Nigeria are clear examples. And there's a different strategy probably in those countries typically. Then there's the movable middle, and the movable middle is the one in which law reform is possible. And those obviously are the ones that we are particularly focusing on in terms of our legislative reform technical assistance, where there is scope for reform, even if there isn't, as there almost never is, perfect consensus. But there's scope for reform. Then there's those that have reformed, and there's the post-reform strategies, which have to include implementation, and which have to include, you know, a lack of complacency that it's done and dusted and you can move on. And that, I guess, it sort of crosses over with that second question, that first of all, never being complacent, maintaining the issues on the agenda, continuing with data collection, continuing with polls of attitudes and things like that, continuing with education and awareness. It doesn't stop when laws, you know, all get ticked off as meeting human rights standards. We see that everywhere in the world. And the UK, you know, is one example where there are risks despite immense progress, including marriage equality, obviously. So yeah, but I think they all have different tactics and different approaches that are necessary. Sometimes you have to just start with hearts and minds because it's hostile, and you just have to start planting seeds and laying the groundwork. In other places, you can be more interventionist and look at a court case or a legislative reform strategy. And in post-reform, you have to be looking at implementation and maintaining all of the successes.
Thank you, Tia. And you're right. We've had another question that I think we're covering this, you know, in these answers. But I just wanted to mention, Farai, Chikwana, who said, in countries like Zimbabwe, where the government has been vocally anti-LGBT, are there any recommendations you have on how shifts in political will can occur? Could it happen at the same time as efforts to change social attitudes? And so if we can include that in those answers, Bernard and Kim, that would be great. And perhaps also interested in how, once we have more progress in countries like the Seychelles and Belize, how you can then use your voice to influence others around you and others on the global stage. Will we come to you? Kim, are you? Yeah?
Yeah.
Okay. I'm sorry. Go.
Okay. So it's interesting that the media was mentioned, because especially in small countries, I find that because of a lack of resources, many of our journalists don't have the time or the resource to do proper investigation or to learn about the process that we go through in putting together these pieces of legislation, in addressing and amending these pieces of legislation. And so a lot of times they just go based on what they're hearing and who's making the most noise. And we all know that in societies such as ours, the ones who make the most noise are the evangelicals, a small section of the evangelicals, and it's just easy for the media to just run with that information. We went through a process in Belize where we made sure that we educated the media on exactly what it is that we were trying to do when we were working on our amendments. Thankfully, we made that intervention at an appropriate time, and the media was then able to see what our objectives were and why we were doing the amendments to these legislation. I think for the in terms of the second question, I think Taya really gave a good overview of the situation from country to country. I mean, it really is a challenge, especially when you have at leadership level the outright disregard for people's rights. I mean, it's my only recommendation to those countries that are facing that type of situation is try to get as best a champion that can help with championing reform in your country. It's someone that is really, really and truly willing to stand up against government.
Thank you so much. Bernard, would you like to?
Yes, thank you, Hannah. Very briefly, I think if I can start with the second question, I think the move forward is inexorable. It's not going to go back. There will be people who will fall by the wayside, and there will be countries that will regress. We need to accept that. In fact, my time in politics, my time in law has taught me that nothing is ever eternal. Things will go back, but the general movement is in the right direction. What can you do? Well, in the face of a strong authoritarian government that doesn't brook opposition or dissent, nothing. Bide your time, and the government will go, and then you'll start again. Nothing is eternal. Some battles will take longer, but they will all be won because they're right and they're fair, and that is the way the world is moving. I don't think there is any room for pessimism. It's difficult to tell people who are living in a straitjacketed country that the straitjacket will be lifted one day, but life teaches us that it will. And life teaches us that it will because of my answer to the first question. What is the role of the media? Well, I think the role of the media is education. And one of the things that is absolutely cardinal to LGBT rights and hate issues generally is education. And education works. If you keep at it, and if you teach people, and generation after generation or class after class, you will get the answer and you will get people to come on board. We've seen it in this country. We are an environmental leader. We weren't always. We ate turtles until not so very long ago. But a generation ago, an education process started to teach people not to, and that turtles had to be protected. And today we have nobody wants to eat turtles. Young kids coming out of school will not go there. We had an HIV, a very positive HIV education system, not only the ABC, but certainly the ABCD system. And recently I was attending a seminar where we were informed that all sex workers, or at least the vast majority of sex workers, used condoms in their, and because they were taught it. So I think a combination of patience, perseverance, and continued education, especially by the media, is the way forward.
Thank you so much, Bernard. Well, I'll say we've got one more question. I know we're running out of time. I would just like to say a word or two. I mean, certainly in Scotland, we've got an incredible campaign called the TIE campaign, the Time for Inclusive Education, and they have worked alongside other charities like Stonewall, but they really have been very, I suppose, radical in their early days of making sure that LGBT education is on the curriculum in Scotland, and others have campaigned across the other nations of the UK. And hopefully in all parts of the UK, all countries, we're going to see that coming to fruition. And I couldn't agree more. I mean, I've been, a supporter of theirs and done a lot of work with them and seeing the real impact. I know for the generation below mine, it's a very different situation. I think young people are much more accepting of different gender identities and sexualities, but there are still significant challenges, and largely they are societal challenges. The fears, I speak to young trans people in my community and their parents are much more scared because they're scared of the narrative. And I have to say, unfortunately, a lot of the stuff that's in the media as well. And so hearts and minds are incredibly important, but so is education of our young people. I mean, we, decriminalised, we got rid of Section 28, and it's been nearly 20 years, since, and we have not implemented anything really as robust as we need across our schools to make sure that young people understand, and indeed teachers and educators, the legislative landscape, but the social landscape and how properly to support young people. So I very much agree with that, and I hope that we can all work together. And if anybody wants any information on the work that the Thai folk are doing here in Scotland, I'd be happy to share it, because I know once they get it in Scotland, they're very interested in rolling it out, and they have had contact from other countries across the world. We've got a final question from Jane Ozanne, and I think this is a really pertinent and important one, saying what work is being done with faith leaders, particularly those who would be seen as accepting evangelicals, to help with pushing for decriminalisation. She says, I ask this as a lesbian evangelical who's been heavily involved in bringing affirming religious leaders together to speak out on this, and I'm keen to help. And I just want to say, Jane, thank you for everything that you are doing, and be very keen to hear what others feel and think about that. Bernard, will we come to you first, since we came to you last time?
Thank you. Well, this is a big one, isn't it? I mean, this is a big one, and we hear platitudes, love the sinner, hate the sin, but they are platitudes, and I think the evangelical opposition is something that will have to be faced head on, and the only way of facing the evangelical opposition is through dialogue, is through persistent and continued and intelligent dialogue. I cannot see how else it will be done. We have it here. When I moderated the debate which led to the suppression or the repeal of Section 151, I had to run the gauntlet from my car to the hall where I was moderating the debate through evangelical opponents to what was happening. So it's very real. It's very real in all of our societies. Well, some more than most, and it's very real here. So it's something that that touches me particularly because I know faith leaders who are extremely opposed to any kind of move towards liberalizing issues around the gay community. So, but the only way we're going to do it is through having a better argument than they have. Engagement and dialogue. I cannot see how else we're going to do it. Thank you very much.
Thank you very much. Tia, would you like to come in on this one?
Yeah, just to say very quickly that, I mean, the number of constituents and stakeholders in this and people that need to be brought on board is huge, and faith leaders is one, clearly. Whether it's the evangelicals who tend to be the more vocal and often aggressive opponents, or other religious groups, and there are many others that have their form of opposition. So engagement with them is key. Engagement with them is happening. I mean, in our experience, it's not part of what we do directly. Our piece is the legal technician sort of role, but there are many people that we partner with in either at a country level, where there typically are at least one or two, if not more, depending on the size of the country, religious leaders who are willing to speak out, despite often great personal risk even, and you know, leveraging and growing those numbers through dialogue, as Bernard suggested, is key, because the more you can bring that community on board and often dispel the myths around their opposition, because it's loaded with myths, is, you know, all the better for the success of any reform initiative. And then there are regional and international things. There are groups of religious leaders being brought together for forums on LGBT human rights, on decriminalisation in particular. There have been faith leaders who have written papers on how, for instance, the interpretation of the Bible is actually not what a lot of people say it is. And, you know, there is a lot of that work happening, and it's very complementary to the legal, the advocacy, the campaigns, the hearts and minds things that are ongoing.
Yeah, absolutely. And I mean, I'm sure you will be familiar with Vicky Beeching and the work that she's done, and the amount that she has, you know, how she's spoken out, and to the detriment of her own health and career. And I would commend her book Undivided to anybody. And she comes at those discussions that she was, for those who don't know, Vicky Beeching, she was a Christian rock star, very much in the fray, and touring in America, and you know, took many years to come out, and when she did, was met with a huge backlash, but has persisted, and I think is a real inspiration, particularly in the faith communities. But she has paid a very high price, as she writes herself, and you know, I think we all live in hope that there will be a day when people don't have to pay such a high price for their mental and physical health, to just be who they are and speak out in whatever community they are. Kim, can we come to you finally for some thoughts?
I totally echo what Taya and Bernard just said. It's communication, it's dialogue. We can't dismiss them. And so I believe that we have to remain engaged. So yeah.
Well, I think we'll wrap it up there, folks, and I just want to thank so sincerely for their time and work. Tia, Kim, Bernard, it's been a real pleasure to host. I know Crispin will be very, very sad that he's missed out. Please know that the APPG on global LGBT rights will continue to fight and campaign, and we look forward to working with you further. And on a personal level, it's just, you know, it's just so inspiring and uplifting to hear of the work that's being done around the world. and more power to your elbow, as my mum would say, and all the very best. And we're living in very strange times, but I hope that for those who are watching from different parts of the world where their rights, they may not have the rights that we enjoy here in Scotland and the UK, that they realise there is people around the world here to fight their corner and to stand up for them. We're with you in spirit. So thank you very much, folks.
Thank you.
Thank you.
Thank you. Bye, everyone.
Bye. Thank you.
Bye-bye.
Mhm.